Well, hello and welcome to a very special edition of our Alliance Against Exclusion and Restraint Live. We're not usually here on Mondays, nor do I usually have a guest right here with me as soon as we start. But we've got a lot to talk about. I'm really excited about today. I do want to say that I am here in Maryland with rain coming down and thunder booming. And Cheryl, I know you're probably getting the same storm. So if we quickly vanish, it was nothing you said, hopefully nothing I said, and nothing anybody else said. So with that as kind of an introduction, Cheryl, let me introduce you. I usually kind of go through the introduction separately, but I figured we would just kind of dive in. But I'm going to give you a little bit of introduction. I might go over everything, but of course, you're the founder and owner of Advocating for Kids and a special education advocacy organization. You do a lot of information and workshops for parents and professionals addressing the needs of Black and Brown children and those from lower socioeconomic status. You've got a Master's of Arts in Urban Education and Counseling, and you completed postgrad credits in psychology as well. And probably the information I have here is probably not even fully up to date. I know you've done the COPA training in terms of advocacy training. You have, I've got a lot here for you. Of course, NAPC as well, and just really have done a tremendous amount of advocating, not only in Virginia, but really kind of across the United States. But I think the most important title that I have for you today is my friend. It's always great to see you. You called me earlier this week, and we were having a great conversation, which is kind of what led to us deciding, hey, let's do a live event, because we were just having a conversation about it. So let me start, Cheryl, by just saying welcome and thanks as always. It's always a pleasure to talk to you, whether I'm joining you or you're joining me. It's great to see you.
Hi, Guy. Yes, I love it when we have our conversations. Whenever we do talk, though, I mean, we deep dive into stuff. So they're always fun, exciting, and good conversations that keep me on my toes. So I
absolutely. And you called because you wanted to talk about this new guidance that we got from the Department of Education. And you and I, of course, started having an interesting conversation about it. And I remember because you kind of laughed at me a little when you said, well, listen to you being, because while I'm glad to see the guidance that's out, I'm always wanting more. And you kind of, tease me a little bit about, kind of that, but I got a lot of great things about this. So that conversation we had was going so well that it seemed like it'd be a fun thing to do, to kind of do it as a live event and talk a little bit about what this guidance is that came out. I'm going to put my screen up for a second and just share a few things. And, of course, the Department of Education on the 19th put out a release. There was a statement from Secretary Cardona as well. And in that, they included a number of resources. So they have a resource called Supporting Students with Disabilities and Avoiding Discrimination, the use of student discipline under Section 504. There's a question and answer addressing the needs of children with disabilities and IDEA that came out from OSEP. And also something about positive, proactive approaches to supporting the needs of children. So there was a lot of guidance that came out just last week. And of course, all of these documents are now available on the Department of Education website, and we'll try to provide some links to those. Of course, I was midway down in the document there, but we've got all of these available, and there's some really good information in these. So, I think based on our conversation, we thought, well, gee, wouldn't it be fun to kind of talk through these a bit and talk through some of the things that, in your role and experience, of course, you're always thinking about it from kind of the advocacy direction. How is this information, honestly, useful to me as I'm advocating for children that you're helping or working with families. So I know that you had kind of put together some notes. Let me get my mouse back here. I'm going to unshare my screen. I'm actually going to pull your screen up for a second. And I thought it might be fun to kind of go through some of the notes that you had given and talk through these different documents of what you think, as an advocate, as a parent, as somebody that's really engaged in this work, what you think is really going to be helpful. So let me pull that up.
All right.
And as I'm doing that, I want to encourage people that are watching. I see some friends already here joining us. see
Hey,
from Autism
Maria,
Black
I'm glad you
saying
made
hello.
it.
Yeah, I got a couple of people. But if you're on watching us, please feel free to tell us who you are and where you're from. And as we're talking about this, if you've heard about this new guidance and you have questions about it, feel free to ask those as we go along. And Cheryl, I know you'll be kind of talking through your notes initially, so I'll do the work of keeping an eye on the chat. And if we get questions, I'll try to pop those up. But I know you're a pro at this too, so you might see the questions coming up. And we can take those as they come. So I'm going to let you kind of take it away, and then we'll start kind of going back and forth and talking about it a little bit more.
Okay. I want to thank everybody that's here joining us, Deb and Sandy and Maria Davis from Autism and Black and Lisa. So please post your questions. We want to hear what you have to say, and Teresa. So let's start off with, there were four separate documents that all kind of came out together. And one side was IDEA. The other side was looking at issues around Section 504. So the ones that I want to cover, which I think are most impactful, believe it or not, in the language, is from the Section 504 piece. So first, there was like a fact sheet. It's a 4-page document where they kind of pulled out information that they found as facts based on data that they've been collecting throughout the year. So I'm going to kind of start with that piece, Guy, okay? And the fact sheet is called Supporting Students with Disabilities and Avoiding the Discriminatory Use of Student Discipline under Section 504 of the Rehabilitation Act of 1973.
And
so
I'll put the
want to
links
start with
as you get to those as well.
Say that again.
I'll put the links in the chat as you mentioned the different documents.
Yes, that's really helpful. I loved the definition of FAPE, right? Now, and it really, I don't remember this Section 2 being in it, but I've always been a fan of the definition of FAPE under Section 504 because I feel like it's broader, that it has more protections. And it's basically saying that, a free and appropriate education provisions are required. Provisions require schools to provide students with disabilities regular or special education and related service. Special education and related aids and services that are designed to meet the student's individual needs as adequately as a student who doesn't have disabilities are met. So that means that the child who may have ADHD, and I'm using ADHD because I'm ADHD and I can give better examples, and it's also easier. Okay, so under this definition of FAPE, they are saying that disability of ADHD, the school has a requirement to provide provisions for educational services, special education services, related aids, and other services. This whole document provides a lot of strong evidence that I've not seen out before, Guy, that really kind of talks about what that looks like, especially when you say special ed or related aids or services. And then it says that they're designed to meet the individual education needs as adequately as a student without a disability. So it's about equaling the playing field when we talk about Section 504, and that's why it falls under discriminatory, right? Mm-hmm. People with disabilities have different neuro needs as it relates to learning and instruction. And the Section 504 is to help level that playing field so that they too can grow and thrive as if a student without a disability. There's also some other pieces here about the division of FAPE that I think are important, that are often overlooked, at least in the cases that I've had this year around Section 504. And that is also the satisfying the Section 504 requirements for evaluation and placement, educational setting, and procedural safeguards. Guy, when I read that, I was like, wow, that's powerful, because generally, at least in my region and where I do engage in Section 504 meetings and plans, school districts are very limited in their knowledge, and they just want to focus on an accommodation. Mm-hmm. They very, very seldom will allow the conversation to even be about a placement, meaning a child with just a 504 going into like an inclusion class or a special education class. So I think it's really, really interesting that they talk about that and they use that language which for me is great. So, because if I'm in a 504 meeting, my kiddo needs to be in an inclusion class with a special education teacher. Now I can use this language and say, wait a minute, the new fact sheet says that this is a consideration. So that was one of the ones that I pulled out as significant and something that I can see myself using very much so in my practice or information that I share.
That kind of struck me as well. And you certainly have a tremendous wealth of experience as an advocate doing this work. And working with people both with 504s and IEPs. I have less familiarity with the 504 plans, but my impression was, well, let me put it this way. Reading this guidance made me feel there was much more strength or potential strength to a 504 than my impression previously led me to believe. And that's a positive thing. And I think that's what you're saying is it puts a little bit more behind that to say, this isn't just about A, B, and C, but it's about anything that the child might need under that 504 plan, including things like placement that you don't normally maybe think about being part of that.
Exactly. And that's why, when we first talked, I was like, I was really impressed with the 504 language because it really gives people, gives parents, gives advocates, gives attorney more to work with. And things that you traditionally I struggle with seeing in the school. I had a couple cases in Maryland this year, and one of them was around a 504, and it was very difficult in getting them to finally agree. Just providing additional aids and supports like behavioral intervention plans, which this document talks about a lot. So I think it's powerful. Do we have questions? Okay.
This is very, I think, kind of relevant even early in the conversation here. And that's around, do children need to have an official diagnosis to be granted support? So from the perspective of a 504 or IP, do you want to take that?
Yes. In fact, that's my next session. My next section on this, that's really great. And my thing is, if your child needs to have a diagnosis, because within the definition of, within explaining what Section 504, it is for people that have, it doesn't use disability as much, it uses impairment, physical or mental impairment. So yes, the child has to have some kind of disabling condition that significantly impairs them to function in major life activities like reading, learning, concentrating, alertness. The list is not exhaustive, which is what I like about Section 504 too. It's a huge list of how the child's disability may impact them in school. I think it's broader than it is under IDEA. And I want to go over the evaluation piece. Now, there's some really, really strong language that I had to highlight and read it here. So I had 4 cases this year where I had the issues that are outlined in here perfectly. That this would have been great information to use. I mean, I was able to get through the processes, but this guidance would have been wonderful to give to the staff. So this is about evaluations. One of I think one of the biggest myths or untrue information about Section 504 is that the parent somehow has the obligation of getting the child evaluated, then bringing a note to the school and saying, oh, look, my child has ADHD or Tourette syndrome or autism or whatever the disability may be. And then the school saying, oh, we want to, then now you're eligible. This document blows that out of the water. It says evaluation schools must, not can or should, or it must. It means they have to do it. And that is in a timely manner. Evaluate a child at no cost to the student's parents or guardians when the school has a reason to believe a student needs special education or related services or related aids, and the student may have a disability. So that's your child find kind of clause under Section 504. I think that gets lost a lot. Like I said, I had 3 cases in one school district where the kiddo was having some behavioral issues. Parent had private diagnosis of ADHD, parent asked the school for an evaluation, and they were like, "No, we're not going to do that. He's fine. He's okay. He doesn't need an evaluation. It's just behavioral. It's just he needs to learn to listen and not be impulsive, or increases medication or changes medication." But the reality of it was that was a violation. They should have at that point immediately evaluated the child. And of course, I got that wrong, and we did get the child evaluated. But I think in parents, please recognize that, like IDEA, under Section 504, your child, the school must conduct an initial evaluation. It must be free to you. And they have this other section that I think is kind of interesting. No cost to the parent or guardian. And regardless of whether the parent or guardian has requested the evaluation, when the school has a reason to believe the student is in need of special education or related aids, including the student's behavior indicates that they may have a student's placement, including a behavioral disability. So to me, that's huge. If you have a kid who is getting referrals, like getting out of school suspensions, in-school suspensions, having disciplinary kinds of things happen to them based on their behaviors, that if you as a parent know it is part of their disability, and an evaluation should take place.
Right.
It's not okay to let the kid struggle. And that's what I feel that they're saying here when they talk about, regardless of whether a parent or guardian has requested the evaluation, if they see this pattern of behavior where they're having these issues with the student, that they have an obligation to evaluate.
Yeah, I love that word obligation, because, when I read this, got the same impression, which is, yes, a parent might bring up the need for evaluation. A parent might be the one that's saying, hey, we think there's a problem. But really what the guidance gets to is that it's the district's obligation.
Yes.
Not just that the district can do it, but they have an obligation. Yes. So, I mean, I think it's even beyond being proactive, which you would hope that a district would be proactive and say, hey, we're seeing these kinds of issues. We're seeing maybe certain behaviors that are leading them to believe that there could be a disability, that they have an obligation, not just they can. Right. It really does put ownership to the district of taking that very proactive stance.
And I would take it even a step further, that by the district not evaluating a student, that they are constantly suspending or restraining or secluding or calling to remove, that they are violating and they are engaging in disability discrimination. I would take
absolutely, and denial of a free and appropriate public education.
Yep. Because they make that language so strong in here for what they need to do. And they even say here, even if the student is doing well academically, the fact does not justify denying or delaying any evaluation when the school has a reason to believe the student has a disability. The school must respond to a parent's request for an evaluation, and a denial of a request can be challenged through procedural safeguards. And that's, I think, something that's absolutely important too. If you go to your school and say your child, within the first 9 weeks of school, your child has 5 behavioral referrals, your child has ADHD, school said, no, your child's not eligible under IDEA for some crazy madness, I say then you go and then you request an evaluation under Section 504. If they say no, I think you have, I highly recommend that you file a complaint with Office of Civil Rights for disability discrimination, because I think this document is developed specifically for situations like that. And we need to have tools in our parents' hands and our advocates' hands so that we can protect our kids from being traumatized by the restraints, the seclusion, the being kicked out of the school, the prison, the school pipeline. That's the only way we're going to stop it.
Yeah. And this one hits home with me a little bit, because I can go back several years and remember essentially being told that, that my son wasn't having academic issues. And in fact, was kind of told, well, that I had to manufacture some issues here to get help for a child. There's so much, I think, misunderstanding out there. And unfortunately, that puts a lot of kids and a lot of families in a really tough place in terms of getting services. A lot of false information that gets carried. But you're right, this is strong. And, I think even, the guidance is only good if we hold them to it. That if we think that there's a denial of, if we think there's discrimination, if we think there's a denial of a free and appropriate public education, the guidance is not doing us any good if we're not filing a complaint, right? Exactly. I mean, don't we need to take some action to really make the guidance useful?
Exactly. I participated in the phone call that they had that day that they released this with the White House. They like to be a little celebratory about what they did. And I was able to get a question in one of my questions, because in Virginia, we don't have any state oversight at all when it comes to Section 504. And my question was that, what about states? Because they made it very clear during that call that this is for school districts and for states. You all need to be doing this. This is something that we're getting feedback on that you're not doing. You need to do this. So my question was, what about when you don't have a state enforcement for Section 504? And their response was, we are investigating. We are taking complaints. I mean, they were very upfront about that. They were like, don't be scared to use this information to file a complaint if you see violations.
Right.
So you're absolutely right, which is why I think that this document's better than the one they did for IDEA. The one for IDEA I thought was weak. It didn't tell us anything new. In fact, it was supposed to be a redo of the 2006 colleague letter also, and it just doesn't have any meat in it. But this one has a lot of good stuff that you don't generally see in guidance department, in guidance documents about the school's obligation. If you are doing this, if you are constantly kicking a kid out of school, you and your staff, you had the obligation to evaluate this child. And when and because you didn't, you denied FAPE and you discriminated. So I want to move on to one other section of this.
Let me just get one question here real quick, because we actually have a lot of chatter going on.
Oh wow!
In the chat, so maybe you can hit some of that in a few minutes. But one of the things that we sometimes hear, and I've been there, when you hear, well, it's guidance. We have lots of guidance out there, but this guidance is a little different in terms of, there is guidance in here that says the Office of Civil Rights would not find that a district was, the district was not following the law if they were doing X or Y. This guidance is really more than just, we think you should do these things. This guidance is really about, if you're not doing these things, it's likely, if you were to be investigated, that these things would be found against you. So Mandy asked, I had a state board tell me that guidance is not a requirement, and that may be true, but this kind of guidance, I mean, this is essentially the Office of Civil Rights telegraphing to districts, if you're doing this, I mean, there's a number of the questions that are asked in this guidance that get to, we would not find that to be reasonable, or we would likely not find in favor of district doing these things. So while this may be guidance, it's guidance based on legality of enforcing Section 504, right? I mean, so this is a little stronger than just, these are things you should do.
So Mandy, you and I are on the same wavelength, because my follow-up question, Guy, when I said that I participated in the White House discussion about this, was her exact comment. I was like, the other issue is that, this is guidance. I've had school boards attorney tell me that it's guidance, that they don't have to implement it. And they were like, you are right. Your school board attorney is right. It is guidance, but it's guidance on the obligation the school district has. So I love the way that she said that. It's like, this is guidance on what you're supposed to be doing. So you don't have to do exactly what the guidance is, but we are telling you, this is what you're supposed to do. This is what the law says. So if you're not doing this, then it's an issue.
Right.
So I just thought that was amazing. She had the same question that I actually asked the White House staff about.
Yeah. But to me, that takes it to the next step, which is, if you're not following this guidance and someone files a complaint, under these circumstances, we would probably not side
Yes.
with the district. So,
And it says
you know,
that, yes.
yeah, exactly. So, I mean, it's very strong guidance. I mean, you know, if you're going to say
Yeah.
that, but I know what you're saying. I mean, we've kind of gone through that before. We had
Sure.
guidance go out in 2012 about restraint and seclusion, and we still have many states that have no laws around restraint and seclusion.
Exactly.
But this is different because there is that legal enforcement piece here, right?
Exactly.
Okay.
And I was very disappointed because, you know, my heart is invested in restraint and seclusion
Right.
work too. And you know, I was disappointed. I was a little disappointed that they weren't a little stronger on restraints in seclusions, but they did include it when they talked about patterns of behavior, that if the school district is restraining a child or secluding a child over and over, then they need to be doing something else, because that's not what they should be doing.
Yeah.
So I did like that language, but
yeah, well, you know,
I would have loved
you and I had a
Right.
conversation about this, and
Yeah.
and I kind of was in that same position, and I've gone back through it, and part of what I thought here is that, well, they do mention it. They do talk about it. They do talk about restraint and seclusion. Now, why is that significant? Well, in the past, of course, you know, what's been said is, well, restraint and seclusion aren't discipline, so we don't include them when we're talking about discipline. But what you and I and so many of the people that are joining us right now know is that restraint and seclusion are used for discipline.
Yes, it is.
So there was this kind of hard line that said, well, we don't talk about these things because they're not intended as discipline. But I think the fact that they're mentioning them here in
Yes.
both the 504 and the IDEA guidance shows the recognition that these things are being used as discipline, and that they're being used in discriminatory ways. So maybe not exactly what I want to see, but it still, I think, is putting some credibility behind it.
It is. I mean, and think about it. Think about like your own personal experiences. I don't know how much you mind sharing, and all the times that your child, say, was restrained or secluded, in any time more than one, or any after that first one, this document reads like they need to be evaluated and even reevaluating and doing more things for supports, because it talks about that a lot. It talks about, and even if a child is receiving services, does have a BIP, but they continue to engage in behaviors, you need to reevaluate again. So from that perspective, can you see the difference in it being helpful?
Oh, absolutely.
I forget, I'm not interviewing you, you're interviewing me. So.
Oh, no, we're having a discussion. You know, I mean, that's what it's all about, is talking about this. But, you know, I mean, I think that things are broadly moving in a better direction. But I mean, you know, where things will never be good enough to me is like, you know, it shouldn't be this hard. It shouldn't be this hard for parents. You know, when we know, and one of the things that's said in one of these reports, and I have to look at which one, but basically talks about data and says that, well, while data may inform what we do, it doesn't necessarily, how did they put it? It was something like, you know, it may be evidence, but it's not kind of primary evidence. You know, wouldn't it be great if we lived in a world where we looked at schools that had these trends and patterns, and we were more proactive? You know, of course, I have a tremendous, you know, I think, and I think you feel the same. I mean, I feel that there's a lot of people that are working in OCR, that are working in OSEP, that are really genuinely trying to make a positive difference. But, you know, I don't think we have the resources we need. I mean, the amount of time it may take for a OCR complaint to move forward, you know, some of those things can really be disappointing for sure. But, you know, I think definitely this is moving in a better direction.
I agree. You know, I filed an OCR complaint, and I was surprised I got the letter acknowledging that they were going to open the complaint fairly quickly. It was like within that 10-day timeline. But their investigations, I've heard people say that they've gone 2 or 3 years.
Right.
And that's a really long time. My position is, though, once the district is aware that the OCR has opened a complaint to investigate an allegation, there's some pressure put on them to try and do the right thing, to try and resolve it. You know, if it's a good district, if it's a bad district, they'll use it to retaliate. But, you know, there are opportunities for it, because there's some good districts out there and there's some horrible districts out there. So it could go either way. But I do want to go back to this one piece about evaluations here. And this is, here it says, Section 504 does not limit the number of evaluations a student may reasonably request or receive. And I thought that was also interesting, you know, because it always feels like school districts tell parents that they can only have, evaluations every 3 years, right? That time instead of once a year, every time it comes up. Or, you know, under Section 504, that evaluations aren't even required. This document literally says, no, you can do, you know, there's no limit on the kind of the number of evaluations. There's also no limit on the kinds of evaluations. So you can do behavioral assessment evaluations. You can do IQ evaluations, speech evaluations, OT, any evaluation that is going to give data or, you know, on what the child needs based on their disability is an evaluation that can and should be done equally under Section 504 as it's done under IDEA. That was the big message I got out of all this evaluation piece. And like I said, to me, that's new. That's something very new. Usually people just look at the one pieces of like a psych and that's it. A lot of times districts want parents to go get the evaluations and don't want to do it at all. And I've even have sat in meetings where the districts claim that the evaluation is just a record review, where no new data is collected. It's just whatever they already have, teacher feedback, SOL, or whatever their high stakes testing may be in that particular state, and determine whether or not the child is eligible under Section 504. And parents, I urge you to stay away from that. You really want to get some standardized information on how your child's disability, especially if it's a behaviorally based disability, because this guidance focuses on behaviorally based disabilities, right? So
yeah, which are often you know, those that are leading to punitive discipline, and a lot of the punitive discipline is itself presenting new challenges for a child potentially. You know, one of the things that I like collectively about this guidance was that there was a real focus, in my opinion, when you looked at it holistically, of saying something that I think you and I and others say a lot, which is that, you know, if we're seeing behavior, it should be a signal to us that we're not appropriately meeting a child's needs. And I feel like I heard that throughout this guidance, but then it took it a step further and said, and if you're not meeting a child's needs appropriately, the next step of that is to do additional evaluation. So that seemed to be very consistent in this guidance, was that, you know, discipline should, in fact, be a reason to look at doing evaluation.
Exactly. I mean, it says that regularly. And it's saying, again, it puts the obligation on the school districts. If you see that, that's your trigger to give some supports. And it also talks about, even if your child has the 504 already in place and you're still seeing some behaviors, you need to reevaluate again, identify if additional testing is needed, identify if additional services are needed. They talk about providing social work services. I think I have that in here. Well, not on the fact sheet. So that was a majority of the information out of the fact sheet. Okay. I'm going to now move down to the actual guidance document, and that's what it was called. Supporting students with disabilities and avoiding discriminatory use of student discipline under Section 504, blah, 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 blah. U.S. Department of Education Civil Rights. I didn't mean that. Sorry. Again, they talk about, here was a section where they talked a little bit about, you know, the restraints. Additionally, schools' inappropriate use of mechanical, physical, other restraints referred to collectively in this guidance as a restraint or the use of seclusion in response to a student's behavior did you see this, could deny FAPE or constitute disability discrimination as explained in their prior documents. And they came out early. That was like on page 3. So, you know, they gave it front attention, which was good, because again, that goes to the idea of what we talked about. Restraint, seclusion isn't for behaviors.
That's right. Yeah, I mean, I was very pleased to see that. I mean, at the end of the day, it ultimately said something very similar than what we saw in the 2016 Dear Colleague letter, which said essentially that if you use restraint and seclusion only once, that it could result in new problems that could result in a denial of free and public education. But I was pleased to see it, like you said, having that kind of priority. And I'm also trying to recall here, I've got my notes in front of me, but that doesn't mean I can find what I was looking for. But I have recollection that there was a previous version of this document, and I went back and looked at the previous version, and I don't think that it mentioned restraint in that previous version, if I'm not mistaken.
I don't think it did either.
Yeah,
I really don't.
Yeah, I went back and looked, and I'm like, oh, well, no, it didn't.
Because I was going back through all of them because I was comparing a couple of them to like,
right.
Because our other ones got archived under DeVos. So these are restating some of those ones that were archived and adding stronger language. So yeah, I was doing the same thing, going back and forth trying to find that too. But they had so many footnotes that I will be checking out later. So I will definitely.
I've been through it a couple times and still not gotten to all the footnotes. We have a lot of comments and questions.
Wow.
I do want to make time to go back to them.
And there's some I want to get to. I see over here too. Yeah. Okay. So
but I want to hit this one real quick because this, I know what the response is in my head.
Now.
But I'm curious what the response is in your head, and I think you just said it, is the burden on the parents to request additional evaluations.
Now, let me go back to this piece right here. I mean, it says about the school. If the school must, in a timely manner, evaluate the student at no cost to the student's parents or guardian when the school has reason to believe, right? So that puts the responsibility on the school district to identify that this kid's struggling, he's having some behaviors. We need to investigate that through an evaluation process. So,
yeah, and back to the point, it's the school district's obligation here, right? It's not just that they can; it technically is their obligation.
It is their obligation, yes.
Somebody asked here, can you anonymously submit a complaint? And I'm going to assume they're talking about an OCR complaint, but can you answer that?
They have it's weird how they do it, but yes, you when you submit your complaint, your OCR complaint, then you have to submit an additional document that's like a release of information of some sort, and they give you a choice of at the bottom, yes, you are okay with the school identifying that you sent it, or no, you would like to be anonymous or some sort. I don't remember the exact language, but they give you a choice. So yes, you can. There was one up here that I thought I wanted to catch real quick. I think I may have lost it. Here it says my nephew. Here it is. The one that says my nephew had a IEP, and was restrained over 35 times. As the school didn't follow the IEP, to me, that's still disability discrimination under Section 504. And let me tell you why. This guidance is about disability-based behavioral disabilities, right? So they literally talk about if a child is constantly being disciplined, whether it be restrained or secluded or whatever, somebody needs to be reassessing, changing placements, providing additional services or supports. And by them not doing that and instead allowing 38 restraints is, I say, disability discrimination and also a denial of faith. So I would just on that fact alone consider filing a complaint with the Office of Civil Rights against your school district.
So let me ask you a question, get your opinion on that, Cheryl. So when you look at that question, you could go a couple of different ways with that. You could file a state complaint because clearly if they're not following the IEP, there's a problem under IDEA, or you could file a complaint through OCR. Now, my understanding has always been that you cannot file the same complaint twice for the same reason.
One or the other.
Right. So the question is, what would your leaning be as an advocate that's been working in this field for, I don't even know how many years at this point, but what would your recommendation be? I always struggle with that because again, there are different remedies that may, in cases, it may be very clear that this is an OCR complaint or this is a state complaint. But in a case like that, I think you could go either way.
So I will say that because we were talking OCR stuff, I said OCR. But to answer your question, because of this document, if this parent hired me and I looked through all of the paperwork and I'm seeing that, yes, this child's been restrained over 35 times or 38 times, there's no bib or the bib hasn't been updated in forever, no FBA is done, no additional counseling services or supports are being put in place, no behavioral IEP goals. None of that stuff is happening. I would go straight for the OCR complaint, and I would use the language in this guidance to make my claim.
Okay.
And
So,
the reason why is because I feel that the outcomes, you can get more from as a remedy that could be systemic. I think easier and quicker in my experiences under OCR than state. And it also depends on what state you're in. Because what if they're in a state where they have no restraint and regulation, no restraint and seclusion regulation. So then I don't even know if you could file a complaint, or how you wouldn't, I guess you wouldn't be able to file the complaint on the restraint and seclusion, but you could file the complaint on the IEP not being implemented with fidelity.
right.
So
yeah, and to further muddy the waters a little bit, there's another option, which is filing a complaint with the Department of Justice, which is investigating actively restraint and seclusion under the ADA, and of course have had some pretty high profile investigations that have led to pretty significant activity. So it certainly gets a little, and I, like you, I kind of think about the impact and what might have the most impact. And, again, it may vary on whether or not it's a systemic issue versus, kind of an isolated issue. But there certainly are a number of avenues that families or parents can go in terms of seeking some sort of resolution.
Even due process. I mean, we can talk about that. Right. She can file a due process under Section 504 or under IDEA or both. That one's a little bit more trickier, but there's some room for that. But she would have to get an attorney. I would highly recommend. I don't know her state, but I would highly recommend she speak with an attorney, because in some states, advocates cannot file due process complaints and represent parents. In other states, they can. So, yes. Okay.
Well, let me let you continue on, and we can get back to some.
About that, Tanya, and I do hope that you will consider making them do better. Hello, am I frozen?
No, you're fine. You're fine. I was going to let you continue on, and then we can get back to some more questions.
With some of these questions?
Actually, let's hit a couple more real quick. Sandra just asked a good one. Is there statute of limitations on Department of Justice complaints?
I don't know.
Yeah, I don't
know OCR, but I'm not sure about.
Yeah. I don't recall either. I believe that there is a time frame, but I don't recall specifically what it may be. But that is a question that we can probably get an answer for.
Yeah, we can Google that when we get off and let you know. I'm thinking if so, I don't even want to guess. I don't know.
Yeah.
I can tell you what they are for state complaints, at least in Virginia. It's a year, and I think that's a federal law. So it's a year from the time the incident occurred.
Right.
If it is a OCR, it's 90 days. And if it went beyond the 90 days, you can request a waiver, but you have to be able to explain why you went beyond the timeframes which within the regulations that they give.
Right. Sandy just mentioned that due process is cost prohibitive for many families, and certainly that can be true. Absolutely.
That's like the biggest lie, I think, under IDEA, and school districts will try and play that up, is that parents can have representation for due processes, and they don't. Even though IDEA says you're supposed to have free or reduced legal resources, none of the people, at least in our state and a couple of the other states I've checked, have a list where you could actually find an attorney that will represent you in a due process that knows how. A lot of the legal aids are underfunded, so they don't have attorneys that are really focused on special ed. They do a lot more with housing or immigration, it seems like. Special ed seems to kind of be on the back burner. You have disability law centers, but not enough of them, usually, to be able to really provide the free and reduced legal services for due process complaints. So it not only is it cost prohibitive, it's hard to find an attorney that is knowledgeable and stands a winning chance in a due process case.
Do you want to go through some more of your notes here, and then we'll come back?
Sure. That's good. So the evaluations. This is just one other piece. That they must that the evaluation must be based on relevant information, not just one source. It needs to be several sources. It says when a student's evaluation shows that challenging behaviors is based on a disability, a team of knowledgeable individuals, usually called the student section 5014, is responsible for determining services and supports. And that's where I think, oh, well, we were doing evaluations. I'm sorry. That's right. We already talked about that. I'm sorry. We did the restraint and seclusion. And they use this term a lot. And I think that we should start using this term a lot too. I generally don't, which is disability-based behaviors. But I think that that is a, when dealing with Section 504, because of this guidance, that is a term that we want to kind of use in our work, in our language, making sure that we're connecting that, yes, in addition to whatever a child may have on one part of their disabilities, because sometimes they're comorbid, whatever behaviors that may get in the way need to be related and discussed on IEP plans, and using this language. And here is where we were kind of talking about, like, if a child is engaged and not identified as a student with a disability, who repeatedly, right, is referred for discipline, inappropriate verbal outbursts beyond the expected range of behavior of a student of a similar age, he may need an evaluation to determine if they need FAPE. And again, this is something that teachers should be able to pick out fairly quickly, right? If they have a kid that's always having issues or not able to live up to the school expectations or the classroom expectations, because a lot of times you have situations where each class will have an expectation, and they actually use that as an example, I think, in the guidance, where a teacher had an expectation that a student could not, if the student interrupted other students, that meant they weren't allowed to participate in an activity the next week. OCR said in this guidance that, that could be a discriminatory practice, because if you have a child that's ADHD that's in that class and they're still working on learning how to do that, punishing them in that way is basically discriminating against who they are, right? Who they are as an individual. And they give that as an example. So I thought it was a great example. I loved it. And here are some other factors that they said you should look at. For examples, depending on the facts of the circumstances, the school's duty to evaluate could be triggered by, and they can say, information or records shared during enrollment. So if a kid's coming in, you see this a lot with preschoolers, right? They're going into kindergarten and their preschool records are, oh, Johnny got kicked out of 2 preschools because he wouldn't take a nap, or wouldn't play with peers well, or was throwing some sand or some rocks on the ground. Right there, to me, then that's a trigger based on this comment, right? Right? Because you're like, you already know he got kicked out of 2 preschools. There's something going on there. So teachers in the school has an obligation. A student's behavior that may harm the student or another person, the observation of data collected by school personnel, information voluntarily provided by the student, by the student or the parents of the students, and then the school's own disciplinary and other actions indicating that school personnel have concerns about a student's behavior. Going to the office, and that's another thing. We just kind of talked about the big ones, right? The expulsion, this, being suspended, short-term, long-term. We talked about restraints and seclusion. I love that they even talk about just sending your kid to the office a lot. Notes home. Oh my gosh. I've seen behavioral logs where, every day the teacher's just documenting how he wouldn't sit down during rug time where he touched somebody, it's like, and then when I get them, I'm like, what? Like, it's like tattletaling. It's like, what can a parent actually do at that point? Because they're not in that academic setting with you to even understand what's going on. And so instead of sending notes home every day, complaining about the behavior, make a referral and get the child evaluated and find out what is needed, what supports are needed.
Yeah, it's almost really damning to have that kind of record of telling everything that's wrong without answering the question of, well, did we have the child evaluated? Did we try to develop a plan to help that child? I mean, continuing to say, if we looked at it in a medical sense, if we had a medical problem and every day they said, here's your medical problem, and didn't do anything different about it, then who's at fault there? And yeah.
And you would be surprised at how often I see that, like, just parents in tears, especially the little ones, the kindergartners, first graders, just in tears because it's so negative. And some of it, you're like, really? He touched somebody? Did he?
Right.
He didn't hit him, punch him, whatever. It wasn't that it didn't cause harm to him or himself, and the other kid wasn't upset about it. But some of the other stuff, the taking off the clothes, the shoes, things like that. I mean, just sending notes isn't enough. That's not going to help that child. And just telling the parent doesn't help the child, because even if the mom comes back and says, and this is what happens a lot, parents will come back and they'll say, well, have you done this? Have you done that? And then they'll either get no response, or the response is, we can't do that because we have to do blah, 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 So it's to me, sending home notes to parents that just complain and document the child's behavior should instead be information that can be used to determine if this child is in need of Section 504 supports and related aids and services.
Yeah. Well, you even hear the idea that, well, we couldn't do that for this student. That wouldn't be fair to other students. And this guidance actually does a pretty good job of debunking that, I think.
It does. It does a really good job in explaining that this child has a disability. You've assessed it. Everybody's established this, and because of that, and I didn't put it on here as much because I want to dig into it a little bit more, because I didn't want to get too excited. But they even talk about changing policies, procedures. They, like how you may have to change your school policy for a student that has a behavioral related disability if the expectation is something that we know they can't do. I mean, that's big.
That's big. Yeah. I agree.
Yeah.
And now this last one, of course, resonates with me because it's talking about, kind of the impact of previous discipline, saying that if you restrain or seclude a child, you might cause them trauma. And of course, that can lead to new academic and behavioral difficulties. And I think that's a really important one, especially, as you look at things like, these adverse or punitive approaches.
Right. Yes. So those are just a few, of what it was like 3 pages, just that quick pieces. But there's, just a lot of information to continue to digest. My most interesting piece is now, watching this being implemented across the districts, right? Getting a case where I get to say, hey, we need to evaluate this kid for Section 504. And I think thank you, Heather, for that correction. I said 90 days. You said, you're right, it's 180 days in order to file a OCR complaint. Thank you for that correction. But I was going to say, I can't wait to try it out and see how they're responding to it. Are they really paying attention to this directive? And then, if they are, and if they're not, is OCR really going to enforce this? Are they really going to investigate? Are they going to, ensure that, and within their investigation, because, if it's happening one time, it's happening more than once. Are they going to make sure that they are looking at it globally? Oh, I can't even speak tonight. Sorry. Are they looking at it from a systemic issue? Are they not going to just look at that one child, but hopefully look at, well, wait a minute, this looks a little bit, you were too comfortable doing this. Are there other students that had that same experience? And if so, causing them to make systemic change. That's my hope. I can't say that that's
so I've got a couple notes here and a couple things that jumped out at me that I'd like to kind of run by you. And I'll start with the first one here, which there was a statement that said a school district would violate Section 504 if it had a one-size-fits-all policy that required students with a particular disability to attend a separate class, program, or school regardless of educational need. Wow. Okay, let me just say, and I know it varies by state, but the behavioral programs that I see across the country seem to exactly be that. They seem to be, this
Yep.
child has behaviors and we're going to put them in a behavioral program. It seems very much a one size fits all approach. That's a huge statement. Considering, I mean, am I overreacting? Am I wrong that, am I just wrong in thinking that a lot of schools are doing exactly that in terms of having programs that, are really one size fits all policies?
Of course they are. I mean,
Right.
some districts use regional programs like they do in the Hampton Roads area. Other school, I don't know what you guys use, but everybody has like that school or that place where they send your more involved students, especially those that have behaviors with it. And to me, yeah, I read that and because I was reading through this again today, and I was like thinking of all the different ways that the school districts would try and say, like, wiggle out of a complaint, like on that, right? Because then there's always that, it talks about that, but then it also talks about how it should be individualized. So if it's a team process and the team says that this is the program the child needs, I'm just wondering, how will OCR really address that? You know what I mean?
Mm-hmm,
It's like yes, my first thought was a couple of our regional schools where they put kids that have behavioral issues, right? I mean, that's where you go.
Well, this is the autism program. This is the behavioral program.
This is that program, and that's the program that you have to go to. And then once we put you in that program, it's like almost impossible to get your child out. But I think that what that statement, yes, does rise to a level of, you could say as a parent, I don't want my child in that program. It's a one size fit all program. You send all kids that have ED, let's say, to this particular program or this particular classroom or this particular school. And it doesn't help my child because my child is exposed to additional bad behaviors from other students. So it's reinforcing some of the things I want to change. And I want to move that child out into another classroom. And if they say no, file a new CR complaint. That would be interesting to see what would happen. I know what you said and I know what you read, but I also know how school districts work. They're going to
of course,
language in there that make it seem like it's the individual needs, that child needs that, and the only way they can get it is there. But I think if a parent can prove that they can still get those supports in a least restrictive environment, then they would be okay.
Right. So, yeah, I mean, I have a lot of concerns and issues with a lot of things that are done in certain ways, by schools. For instance, when it comes to inclusion or being with peers, how many schools out there are keeping kids in segregated classrooms and pushing them out into the general education setting for recess, lunch, music, or whatever it may be.
Library
Probably
time.
some of the most difficult situations for kids that might have, sensory concerns, or, they're unstructured, I mean, and it's done because that's the program. That's the way they do things. And I remember fighting back against that locally. And, I mean, the amount of pushback I had to saying, hey, well, we've got to meet his individual needs. And, recess in a general education, or rather PE in a general education setting is not an appropriate setting for my son. Yet there was a tremendous amount of pushback. So I agree with you. I mean, very often schools are using programs. And there's also, there's racial, issues there as well. I mean, you look at the number of Black children that might end up in a behavioral classroom versus, or even with the diagnoses, end up with the different diagnoses. So, I mean, I have a lot of concern about most of the behavioral programs that, I've seen happening.
They're very dangerous. The ones that we have access here are very dangerous because they, the school districts pay money for them to house our kids, but that's also where our restraints happen. And that's where we have our seclusion rooms. I mean, that's, you know how I feel about them. So one of the tricks I always tell my parents, don't give consent to allow them to restrain or seclude your child, and they'll have them out of there in a heartbeat. That's one of the requirements. Well, in here, CSAPs, that's one of the things they require, that if that we have to be allowed to restrain your child. And they've actually said that we have to be allowed to restrain your child to protect staff.
Right.
So
Yeah, it's interesting. I think I've got a social media thing going up later tonight. But as I was reading this guidance again, one of the things that hit me is thinking about discrimination. In my opinion, if you're building a seclusion room inside of a special education classroom or near a special education classroom, that signals to me discrimination. You are showing that you have an intent to use it on certain students.
And it talks about stereotypes, right? So, hey, are you going to file a complaint?
Yeah,
because that's a stereotype. Because they even said you cannot use stereotypes about students with disabilities, various disabilities. And if they are building those specifically by sped ed or in sped ed classrooms, that's targeting.
Yeah. Well, and they almost exclusively build them in sped ed or next to sped ed. No, I think that's a huge issue, and I do want to take that up with OCR in one way or another. Maybe it is a complaint, but maybe I can reach out for a conversation.
Let's about it. Yeah, especially new guidance and say, hey, I just saw this. Hey, look, would this rise to that level?
I don't know how it can. If you're saying the discipline should not be, how can you build a seclusion room? It doesn't fit at all. Let's talk a little bit about and I'm trying to find the language that was used here, but we know that there are a lot of instances where children with disabilities are having shortened school days. And this guidance certainly hit on that quite a bit, talked about and I've always called them illegal send homes, but how many times does a special education parent get a phone call, we can't handle them, come take them home. It's not necessarily being recorded as a suspension or expulsion or anything else. Did you have any reaction to the guidance kind of talking about that? And it seemed like there was a lot in there in terms of like, that all of this time that kids are being sent home should be accounted for.
Yeah, I loved it. It had really good language about it. It gave like several examples of what that could look like, and it also even talked about requiring parents to participate in activities and for just students with disabilities, which is also a discrimination. So I thought that was wonderful because that happens so much. They, students are told that they can't go on field trips or they aren't allowed to participate.
Or only if a parent can go.
Only if a parent can go. And then usually there's a fee with that, right? The school doesn't pay for that. So that is definitely, that's probably one that they would love to get and could resolve pretty easily by, and that should be reimbursement of any financial expense it caused the parent to go on that trip. Because other parents wouldn't have had to have that burden of paying for it. And also just like within school, it doesn't even have to be out of school. How about in-school auditorium events, pep rallies, things like that? Are kids with disabilities allowed, and are they making it making it so that they can also be a part of the school community?
Because that's exclusion. Otherwise, you're excluding kids. There was another. I just put my own quote up here because this was something I got out of the guidance. Nonetheless, OCR's continued enforcement experience reflects that many students with disabilities face discipline because they are not receiving the support, services, interventions, strategies, and modifications to school district or district policies that they need to manage their disability-based behavior. This is that point we talked about earlier, but I love, like you said, that it mentions policy specifically.
Yes, it does. It does. It really does. And that for me was very huge. That was big because we have my mind started going into how can I use this? What am I going to be doing to use this to make some changes where I provide advocacy services? And I know like one of our school districts, Virginia Beach, they have an outer zone policy that specifically talks about if a child has any kind of behavioral infractions, referrals, or any incidences like that, that they're not eligible really to access that outer zone waiver option that other students will be. And to me, that's disability discriminatory because if you have if your child's disability involves behavior issues, then you would be excluded from being able to have an out of zone waiver. So yeah, I think that's what they're talking about when they're talking about policies, right?
Right, right.
Yeah.
One of the other things this guidance did that I thought was really helpful was in more than one of the documents. I think in both of those documents that we've gone over, or yes, in both of the documents, and I'm actually going to pull my screen up here for a second.
Okay.
They did something really great, which was they provided definitions. Now, why is this great? Well, for a lot of reasons. One, of course, I never was more amazed when working with the school district to have simple definitions conflated. But, when you go to a school district and you talk about something, very quickly you find out, well, we're not really quite sure what that means. I mean, listen, I've heard it for all sorts of things. I mean, when I started with Restraint and Seclusion, it was, well, we don't know what imminent serious physical harm means. It might mean something different for you than it means to me. And I think words typically have meanings and definitions that should be fairly universal.
Yeah.
So
one of the law,
right. So they provide a lot of definitions here, which I think are helpful because, again, I have never failed to have been amazed by how squishy things get when you begin talking about things. So they have definitions here about exclusionary discipline, about corporal punishment, restraint and seclusion. Why is that important? Well, there are states that lack any laws or definitions around these things. Right. And one of the definitions, of course, that I was happy to see, and I think the context by which they defined it was different than the context by which I initially read it, but they talk about serious bodily injury. Now, serious bodily injury is defined under IDEA. And what's interesting is serious bodily injury has the same meaning as serious bodily harm. And that is the standard which they have long said is when restraint and seclusion might be considered in a situation that involves imminent serious physical harm. And the definition there, and I'll just go over it, but I mean, if you look at the 2012 guidance, it says you should not restrain or seclude a child unless there's a crisis situation. You've tried everything else possible, and it is necessary to protect the student or others from imminent serious physical harm. Again, same definition.
Or property damage.
Injury. Right.
Yeah, in Virginia, property damage is added.
Right. Well, but at the federal level, it's imminent serious physical harm. And I don't think property damage is ever a reason to restrain or seclude a kid because, restraint in particular is what I would say is potentially deadly force. Kids have died being physically restrained. It is potentially deadly force. When do you use potentially deadly force on a 5-year-old? I don't think you do. But, they go into the definition here and they say it's substantial risk of death, extreme physical pain, protracted and obvious disfigurement, protracted loss or impairment of a function or bodily member or organ. This is a high bar. And I'm glad to see that definition there because I had to fight school districts about what that meant. And, I'm looking forward to, and while I don't, have any crystal ball here, but it's my understanding that 2012 resource document on restraint and seclusion is also going to be refreshed. Okay. And I'm hoping that guidance brings forward the same definitions as well, and also takes some stronger stances on things. But I do think the definitions are really important for having in here, and I do applaud them for doing that. I also love the format of, I'm trying to remember which document, but there was essentially the kind of Q&A format that talked about.
That was the one for IDA. Yeah.
Yep.
Q&A.
Yeah. It does a great job. And there was one in particular, in fact, let me cheat here because if I cheat, I'll find what I'm looking for.
And there was one more piece too I wanted to share that I just found. So how long are we here for? I want to.
Cheryl, until you tell me you have to go, but.
Really? Okay. Yeah.
I planned till 7 or 7:30, but
okay.
We can keep going for a little while. Let me point out this one piece, then I'll bat it back to you. Okay, and this again was one that was really meaningful for me, which was, does the Office of Special Education Programs consider restraint or seclusion to be an appropriate strategy for disciplining a child for behavior related to their disability? No.
Right?
OSEP is not aware of any evidence-based support for the view that restraint and seclusion is an effective strategy in modifying a child's behavior that are related to their disability. That's huge.
That is
absolutely
beautiful. Yes.
Yep. All right, you take it away. I'm sorry.
Yeah, I like when I think about that. So, maybe parents can put that as their parent comment. The new guidance says, boom, just to make sure. I forgot about this point that, talking about examples again, that they said, here was another section that was pointed out that I did highlight. I forgot to continue to scroll down. This is called Identifying Necessary Behavior Supports, including Behavioral Intervention Plans. And this is where they were talking about if other activities. So, you've done the initial behavioral plan, maybe the kid still needs some additional supports. And I love that they talked about, look, counseling sessions. How often do you hear that service being offered under Section 504? I don't. I mean, I bring it up, but I don't hear schools like, oh yeah, we can put them in some individualized counseling and help them work on that, deregulation issues or whatever. You never hear that. School social work services. I think that's huge. And that could be bringing in community supports too, that the student needs to be helpful, to be able to access education and instruction. They have school-based mental health services, physical activity, and opportunities for the students to leave the classroom on a scheduled or unscheduled basis to visit a counselor or behavioral coach when they need time and space to cool down or self-regulate it. And self-regulate, of course, not a seclusion room.
Right. Yeah.
But, cool down.
So, I love that. The only change I would make in that language would be or co-regulate. We often forget that a lot of our young students have not even developed the capacity yet to self-regulate, and really need the well-regulated prefrontal cortex of an adult to help them if they're having a hard time. But I agree with you. I think that's great. I did not and have not yet had a time to really dive into the other document, the positive proactive approaches to supporting children with disabilities. Okay. Did you have any other feedback on that, or have you had a chance to dive into that?
Yeah, I kind of dove into it. And to me, it felt very familiar and similar. Right. Nothing like stuck out like, oh, this is what I need. They did talk a lot more about COVID, the impact of COVID on students, the need for paying attention to some more of the social emotional needs of our kids. But I actually felt like when I did them all, I read them all, I went through them all twice at least. Right. And I was more disappointed, like I said, with the Q&A one, because I just felt it didn't say anything that it hadn't said. It really did felt like it was just redoing the one that had been archived.
Gotcha.
I didn't notice a lot of new, rich language, but I was glad they pulled it out of archive for sure.
Right. Yeah. And I'm always happy to see people talking about proactive strategies.
Yes.
I have some mixed feelings on whenever I see
the
evidence-based.
MTSS.
Some mixed
I have
feelings
major concerns. Maybe that's why I wasn't excited, because I'm not a big MTSS fan.
Yeah, and no, I agree with you, and I have a lot of concerns around PBIS as well. Certainly, I think there may be some things that are useful here, but I've not had the chance to really dive into this. I was pleased though to see talk about universal design for learning. Okay. Kind of a UDL approach, which is basically where you're making a universal approach that makes things accessible for everybody. There's a lot of promise, I think, in UDL, but I don't know, when that ever comes to fruition.
The problem with these are like things that they should be doing anyway, right? And maybe that's why I'm not as impressed, because I'm feeling like they went to school to learn these. These are things that should be happening anyway in our schools.
Right.
And then they're doing the FBA thing, and then a lot of people are moving away from the idea of the functional behavioral assessment being a really good tool to understand the student, right? Because there's that idea that, and it happens a lot. I see it. It's something that's triggered that happened weeks ago that the child's responding to that can't be an antecedent at that particular moment, or there's just so much.
Yeah, no, I agree with you.
It's bad. I'm just saying that.
Yeah. Well, not to mention, in all fairness, Cheryl, you are a fighter looking for things that are going to help you strategically.
Yes, that's what it is.
Kids, and this is, I agree with you. A lot of these are things that should be done to provide that free and appropriate public education to kids. But when you get into the guidance, I do think, and I'm going to take this off the screen, but I do think it was strong, and I do think it was strategically helpful when you're trying to figure out how to support a child that's going through this. You're in the sticks of this. I know very often,
Mhm.
and that's what you need. You need things to
Right.
support what you're doing. Well,
And
let
I
me.
think that other document did have some really, really good information for parents to kind of understand what MTSS is,
Right.
because I don't think schools do a good job in explaining that to parents. And I think that idea that it needs to be research based, that it needs to be monitored, that they need to keep on top of that. Like, I think that's, there, but I think it could be in more friendly language so that parents can use it. I myself
Right.
know
Right.
that the way that they described it there, and then the way that it's being implemented in some areas is different. And
Yeah.
when you have systems that are already have a program that they've invested in, that's embedded in their budget and in their curriculum, and when it doesn't have all the components, it's really hard to get a school district to shift
Mm-hmm.
without a big fight. But you're
Hmm.
right. I do look for things that I can use to better my services for my clients, or just for any student, like we're doing here, or
Right.
give people tools, information to protect your children, and make sure that your children have opportunities to grow, to learn, to read, to write, to have friends, and to be safe while doing it.
Absolutely. Yeah,
Yeah.
and they do talk about that a lot, which was
Yes.
something else I was happy to see, kind of the feeling of safety. And I'll have to find, there's a quote that I think
Yeah, they
Diana
said a lot.
said I like.
You know what I liked? I liked at first. I was like, oh goodness, I wonder if this has to do with school shootings, and them coming out with a document. Because my fear is always that kids with disabilities or students with mental health issues are going to be the cause of why all this stuff happens,
Right,
right?
right,
Not
right,
looking at
right.
anything else. And I was fearful that the document was going to give school districts permission to perhaps do the opposite of what it actually does,
Right,
because of
right.
the fear with school shootings. But they're very clear. They even talk about threat assessments in one part of it. Guy, they were saying that schools that use threat assessment, or have memorandum of understandings with police, that
Right.
they also too need to understand that what disability discrimination looks like for a student that has a disability, that has behaviors associated with it under Section 504. And they
Mhm.
recommend that the teams work together. Like, if you're going to do a threat assessment on a student that has a Section 504, make sure somebody from the Section 504 department in your school is a part of that, so they're not discriminating against the
Mhm.
student.
So I think you're just saying what I was thinking here, and tell me if I'm saying this the right way. But one of the things that stuck out to me about this was it was very clearly put
Uh-huh.
that if you are a local education agency and you are in a contractual agreement, under
Mhm.
a MOU, like a memorandum of understanding, anything with law enforcement or with other contract support, that
Yes.
they are still held to the standards of discrimination that the school is. So if the school is contracting or has an agreement with law enforcement,
Mhm.
those law enforcement officers or those contracted employees or that contracted school are still responsible for meeting these standards, right?
Exactly.
Yep. Yeah.
Yes.
Yeah.
Yes.
That was really
That
clear in that guidance.
Yes.
Yeah.
That
Yeah.
was big. That was huge in there, because
Right.
think about when that doesn't happen, which I'm sure it doesn't happen a lot.
Right.
At that point, I think everybody goes to crisis mode, and they forget to realize that these are students that have disabilities, and we need to
Right.
make sure that we're approaching this so that the outcome is safe for everyone,
Right. Right.
whatever it may be.
Yeah, I found that quote, and it was entire school communities benefit when all students
Feel
feel
safe
safe,
and
seen,
supported.
and supported. I just love seeing that language there, because
I do
that's
too.
language
It's
that
pretty.
resonates with me. I want to try to have a little bit of a lightning round and go through. We have so many comments and questions here. We will
Yeah.
not get through them all, but I thought maybe we could quickly try to address a few things, and I'm just going to pick out
Okay.
a few here.
You pick them, and we'll do our best.
How do you quantify data on restraints when schools aren't really required to report it?
Well, they are if they are restraining, right? If
Yep.
they have a state law, do I have to go back up? Like, so if they have a state law, as I understand it, part of the state law needs to be about recording it. And don't they have to report it to Office of Civil Rights anyway if they're restraining?
So yeah, they may not have a state level reporting requirement, but
They'll have
all
a federal.
states are required to report restraint seclusion data to the Office of Civil Rights. So, Trina, they are required to report it, but as we all know, it goes vastly underreported. The Government Accountability Office actually came down on the Department of Education, Office of Civil Rights, saying we've got a problem. There's lots of districts that aren't reporting it, but there is a requirement. Some states do have state level reporting, and if your state does not, advocating for that kind of legal change can be a good one. We do it here in Maryland. I know some other states do it as well, but getting state level data can be really helpful.
Very helpful. Yeah. And also you have to be careful with the data. Always assume it's underreporting. It's underreported, in my opinion.
Vastly underreporting, vastly. Here's an example for you, Cheryl. So what's the latest data? 120,000 restraints and seclusions, according to federal data. When I looked at Maryland at the last full school year, we had about 28,000. Now, does that mean that Maryland was 20% of the entire country? No. Wow, yeah. What it means is our Maryland data was, and probably did not agree with what they submitted to OCR. So there's a big problem on the state level reporting. And I remember asking questions at our district like, well, gee, you're required to report these things at different levels. How do you do that? They had a totally different chain of custody for numbers that got reported to OCR and numbers that reported to the state. Make no sense at all. Yeah. So Tanya said, loving the new guidance, but what are your feelings that it will have impact at reducing restraint seclusion? They previously had the 15 principles document that didn't seem to reduce restraints.
So the 15 principles was only for states that had my understanding of the 15 principles wasn't that every state was going to be implementing that. It was only for states that had restraint and seclusion laws that they were going to develop, and that they were just recommendations. They weren't really guidance because there's no federal law about restraint and seclusion. Unlike what we're saying on the Section 504 disability discrimination, we have a law that says you cannot discriminate against a student with a disability. So the guidance is how to make sure that law is honored. My belief is that hopefully not, I don't know about reducing restraint or seclusions, but I hope that the guidance and that parents can see this as an opportunity that if your child is being restrained and secluded and they're not getting services, immediately they need to be getting services. And that part of those services should be to avoid the child being restrained and secluded, and that they use some of the other behavioral intervention recommendations that the guidance talks about. So I don't know if it'll reduce, but I think it gives parents and the community a tool that if it happens once, immediately, hopefully you can get in there and intervene before it gets worse.
Right. Yeah. I mean, that 2012 document, the 15 principles, was really guidance like we were talking about before. Guidance without teeth, really. Meaning that this is what the Department of Education thought was the best approach. And I think the hope had been that guidance would influence states that were developing laws. And it did in some cases. Maryland, my state, followed a lot of the guidance that was offered. But there are some states out there today that still have no laws around restraint and seclusion. So you're absolutely right. Yeah, I mean, it is crazy. What makes me feel optimistic, one, like you said, Cheryl, it's a tool. But it's only a tool if we use it, right? So if these things are happening, and parents complain and put in official complaints, we have more chance of influencing a change. So it's a tool that's only effective if we're actually leveraging it. But I do think that, we heard Secretary Cardona. I was attending an event where he spoke and talked about restraint and seclusion. The inclusion of this and all of this documentation focused around discipline, to me, is an indication that the Department of Education, both in the Office of Civil Rights and OSEP, are looking at restraint and seclusion seriously, and that they want to do things to cause a change. So I think be optimistic, but know that nothing will change if we don't stand up for change. If we don't encourage people to file complaints and to take action to defend their children's rights, little will probably change. But I think we can.
Yeah. What is there an update on it? Because I knew, excuse me, you've been extremely active with Bobby Scott, Congressman Bobby Scott, for the ESSA. Every student, not ESSA, CASA, right? Right. Keep All Students Safe Act, right?
Yeah. So and of course, that's the federal bill that's been introduced, the Keep All Students Safe Act. It would ban the use of seclusion. It would ban prone and supine restraint. Most importantly, it would add funding for alternatives, how to better support kids and teachers and staff, which I think is really critical. That bill currently has more co-sponsors in the House than ever before, more co-sponsors in the Senate. But last I heard, it was still remaining still. I've actually put in a couple emails recently to one of Bobby Scott's staff folks to find out where that is and if that's moving forward. I think, my honest opinion, Cheryl, I don't know if it will pass this time. I think at some point it will. But things are so unpredictable right now that it's hard to know when that'll happen. So, I remain optimistic. I think, and you, I think we both agree, this has to be federal law.
Yeah,
it is discrimination.
It is.
While OCR said, well, we don't look at data alone. When you see 80% of restraints and 77% of seclusions, that to me just spells discrimination, right?
But they did go a step further to say, however, if you pair it with.
Right.
So you can find one student out of that 80%, you got them.
Right. Let's see. Nomius Maximus. Here we go. Ever needs an interview with an adult who went through it. And I would encourage you to reach out to me. My email is Guy Stevens, STEPHENS @nseclusion.org. We're always looking to share stories of individuals that have been through this. And again, sorry that you've experienced this. Know from the many parents and my own child as well that have gone through this, how difficult it can be. Let's see. I'm just kind of looking through a few of these here. We've talked about the guidance issue.
There's so many. Wow.
Yeah, there are. We got a lot of feedback here, and I kind of went back up to the top for a second, just because I wanted to have a chance to look at some of these comments here. Let's see. Somebody said there's so many teachers that are hushed. I'm prepped not to refer students to testing for special education. Yeah, and I mean, there certainly have been issues like this where states are trying to suppress numbers in terms of a number of students that are identified.
Yeah, and that's part of the retaliation, which they're a protected class too, right? If teachers, I know some of my biggest cases, my Chesapeake 6 case, had it not been for a teacher willing to go against the norm of being hushed, we would have never known what was happening. And I just encourage teachers to, if you can, put it in, try it anyway, put it in. And if they harass you, you can file a complaint. I don't know if you're in a stage in your life where that's an option, right? If you're a single parent, I get it, and you're raising your own children, you have financial obligations that you have to be responsible for, and you don't want to risk your job. But if you are in a place where you are willing to speak up, there are protections. You can also sue on your behalf for retaliation if they retaliate against you. And if you can't do that, then sneak them a little note. Somehow communicate with the parent and have the parent make the request. But I think it's an absolute shame that, we get a guidance that says the school's responsible for doing this. But then we know that teachers who may want to make these referrals are being told not to, being hushed, being harassed.
Right. Yeah. Well, I mean, we had a teacher working with us, many years ago, before. Well, my son had an IEP, but it was very simple at the time. It was just some speech goals, and calling me from home, from her home at night, and sharing information with me, kind of on the lowdown, because she was afraid. She was afraid to talk, and that teacher really helped us to get things moving along. But it's sad. I mean, we talk about retaliation. And you know this well. You know this well. Yes. I'm trying to think of the young woman who we had talked to before, the teacher.
Yes.
Her name is just
my gosh.
Yeah.
Amani.
Yeah, Amani. That's right. But teachers are retaliated against just like parents sometimes.
Yeah.
All right, let me work through a couple more of these.
For doing it first.
Right. Yeah. I had a lot of issues working in schools because all of the discrimination I saw, I was told I could not even pass my card to parents or teachers on school grounds. I don't know what your role was there, but it doesn't unfortunately surprise me. Let's see. Somebody mentioned not filing a complaint, but they didn't get in with 180 days. And you did mention that there is the possibility. Okay. Yeah. Yep.
You can ask for a waiver. You just have to explain why. And and this is a reality of it, is a lot of times parents don't realize they can even file a complaint on a particular issue until after that time period has passed. Because say they listen to us and they're like, oh, wow, I didn't realize I could do it. Use that, give a reason for why you didn't. And if it's that you didn't know that you could file, make sure you let them know that you didn't get procedural safeguards or you didn't understand them, and they may accept it.
Right. Yeah, I mean that's one of the roles that I hope that the Alliance can serve for people that are going through things like restraint and seclusion, is to let people know. I mean, these are the things that you can do. People don't know. I mean, there's a lot of people that are past that time frame. Let's see. Heather said, even when a state does block seclusion, schools still use it as a behavioral intervention. They just give it a cute name and don't document it. That's a big concern I have, and I've actually spoken to Heather before.
That's a reality. That's a reality that every parent that sends their child to school starting in Virginia in September is going to have to face. And that's scary because you don't know what that means, because that one restrainer, that one seclusion could be the end of a child's life.
Absolutely. Yeah. One restrainer seclusion can not only, be the end of a child's life, can be the start of trauma and a lot of difficulties for the child, the family. It's heartbreaking. Well, I'm going to go down to the bottom and see if there's.
I'm so upset about Cornelius Frederick. That is like one of the most horrendous cases when I did my presentation for Autism Black. I kind of did a really deep dive into that, and we watched the video. He literally threw a sandwich. And he died for throwing a sandwich. When did we as a society think that was okay to treat our children like that?
Oh, absolutely. I shared something on social media today. It was from a friend and advocate who is working around the troubled teen industry. And he had spent time in a religious behavioral school where he was routinely restrained and secluded. And he shared a report with me that he allowed us to share today for a restraint that lasted nearly 2 hours. And, I think he made some comment, and I don't remember what it was, something like, some pretty, simple comment. It wasn't anything profane, and ended up being restrained for almost 2 hours. And, the things that, and the whole report was there. That's what's really damning. You read these things, and very often the reports, people tell the truth about what happened, and the truth is really damning.
Yeah, it is.
You did what?
And you're okay with putting this in writing?
Right.
You're justified. And that means they're desensitized to it. They think what their actions are through either their training or what's been allowed to happen, that this is okay and this is the only way to do it.
Right. And no, absolutely. And, it all goes back to kind of that simpler problem that, we talk about restraint seclusion, but it's restraint seclusion, suspension, expulsion, corporal punishment. 19 states still now allow that. But even more broadly, Cheryl, it's really about what? All the things that are done to kids, very often kids with disabilities, Black and brown kids with the trauma history, in the name of behavior, right? And rather than focusing on, how do we help kids that are having a difficult time? It's all punitive. It's all about consequence. And, I keep going back to this idea that, and it's a simple thing, but, if a kid can't read, we don't set a book in front of them and then hold up a cookie and say, read the book and I'll give you a cookie. If the kid doesn't have the skill to read the book, the kid can't read the book. But with behavior, we kind of do that same thing, right? We say, okay, well, we know you're not able to meet the behavioral expectation, but here's your reward, right? Here's your cookie, here's your Skittles. Kids need help developing the skills they lack. Kids need help, with having appropriate accommodations, but very often, people look at even very young kids and think it's all like intentional, like, these 5-year-olds. How many times have you read, I'll ask you this, how many times have you read something in a report or something you got back from a parent that had this elaborate thing that they're accusing a 5-year-old of doing, that not only did the 5-year-old probably not have the capacity to do it.
Yes.
I read things about my son and I'm like, I don't even know that I could have come up with that. And you're accusing my son of doing this?
I know. I hear the student, little Johnny chose to do this. They chose. it's not even a choice for them at that point. They are just trying to grasp what is expected of them and what can they do. And it is hard. Now, I know it's hard. Behaviors are hard. But I think our system, our educational system makes it harder because it's so institutionalized, as is it from a perspective of you have to fit this perfect little box. And if you don't in any way, whether it be your race, your disability, your sex, your even I think kids that are extrovert with more confidence, just for whatever reasons, they'll have a better experience in our public education than anybody else.
Right.
Our public education needs to be refocused and realize that we are so different as individuals.
Right.
And to embrace that, because there's a lot of good stuff in it.
We make expectations of kids we would never make of adults. Exactly. We make expectations that don't take into account disability. I mean, for years, my son had on his IP about, looking at making eye contact. Now, if you're neurodivergent, eye contact may not only be uncomfortable to you, but maybe antagonizing for you. Exactly. Putting this rigid set of expectations on human beings. And I would say, I mean, to me, one of the biggest issues is this idea of compliance, right? It's all about compliance.
Ooh, it's all about compliance.
We've got to make kids comply. And what do we want for our children? Do we want them to be compliant, or do we want them to be creative? Do we want them to be thoughtful? Do we want them to make connections? Do we want, compliance, not the top of my list by any means.
Mine either. Yeah. And but I'm neurodivergent, so compliance is just for me an opportunity to challenge you. Right. It is. It's almost like this sense of compliance for what? And that's another good thing, parents, while we're talking about this. This is very, very important, what we're talking about as it relates to this Section 504 document, from a perspective of when you get your classroom expectations this year, compare them to what your child can do and can't do. And if your child can't do some of the stuff that they have on there, you need to call a meeting with that teacher. You need to get a 504 plan or have a meeting with about your IEP. That's a really good way to kind of stop some of the issues before they start. Mm-hmm. Really pay attention to what those teachers are expecting of your child. And if it's unrealistic, then you have a meeting about it and you make arrangements so that your child can be accommodated or modified through that process.
Mm-hmm. Well, listen, Cheryl, we've gone past time. I promised I wouldn't keep you past. So I know you've got to go in as well. Yes. But this has been a great conversation.
It always is when we talk, Guy.
Yeah, I mean, I was excited to when you called the other day and we were chatting. But it's even more fun to share the conversation with others and to talk about this. And my hope is always that in these conversations, it's going to benefit somebody. And I think you've offered some really great input. Let me ask you too, I know that you are an advocate and that you, through the wonders of, the changing world, probably advocate for kids now all over the country, attending meetings via Zoom and whatnot.
I'm giving you my email. You have my email address.
Well, the best thing is you have it right behind you right now.
Oh, yeah.
Which is what I was just going to plug is the Advocating for Kids website. And I'm going to put that in the chat as well.
Great.
But if people want to get a hold of you, they could reach out to you through the Advocating for Kids site. And your email is there as well. And, I just want to thank you, Cheryl, for prompting this discussion and, for having it with me tonight, and encourage people if they have an interest in or are looking for more help that you can be a great resource for folks as well.
Yes. Please reach out to me if you're interested in some trainings. I'm going to be doing some trainings. Thank you. Coming up on a whole bunch of stuff, but I think I'm definitely going to do a training on behavioral what are they calling it? I said I was going to call it disability behaviorally based,
right?
Because I think that this document can really, really help parents protect their children and help parents help their children have a good school year. So
absolutely. And it's going to continue to be a tough school year.
Yes.
Last year was a tough year. This year will be a tough year. Yeah. It's going to continue. So Cheryl, thank you so much. Thank you everybody that joined us tonight.
Thank you everyone.
And we'll see you again soon.
All right. Bye-bye.
Bye-bye.